The only people who don't want to disclose the truth are people with something to hide.
The next item on our agenda is a draft advisory opinion. First, I believe we have some late submitted documents. Vice Chair, do you have a motion, please?
Yes, I move to suspend the rules on the timely submission of agenda documents in order to consider the late submission of agenda document numbers 11-48, 11-48A, 11-50, and 11-52. Thanks.
All those in favor say aye.
Aye.
Opposed? Motion carries 6-0. Thank you. The draft advisory opinion 2011-15 is on behalf of requester Abdul Karim Hassan. Ms. Waldstreicher from the Office of General Counsel will present this advisory opinion to us. Please proceed when ready.
Thank you, Chair Bowerly. Good morning, Commissioners. Agenda documents 1148 and 1148A are three alternative drafts that respond to an advisory opinion request submitted by Abdul Hassan. Mr. Hassan is a naturalized U.S. citizen who has publicly declared his candidacy for president in 2012. He indicates that he satisfies all constitutional requirements for the office of the presidency except for the requirement that the president be a natural-born citizen of the United States. The request asks whether Mr. Hassan may be considered a candidate and a person under the Act, as well as whether his status as a naturalized citizen makes him ineligible to receive public matching funds under the Matching Funds Act. The request further asks whether Mr. Hassan would violate Section 441HB's prohibition on fraudulent misrepresentation by soliciting contributions, and whether he is subject to the Act's provisions regarding expenditures, contributions, record-keeping, and reporting. All three drafts conclude that Mr. Hassan is a person under the Act's definition, and that although he is not yet a candidate under the Act, he will become one when he has either received more than $5,000 in contributions or made more than $5,000 in expenditures. All three drafts also conclude that Mr. Hassan would not violate Section 441HB by soliciting contributions, and that the Act's provisions regarding expenditures, contributions, record-keeping, and reporting apply to him as they do to all candidates. The drafts differ in their responses to Question 2. Draft A and Draft C conclude that Mr. Hassan will not be eligible to receive public matching funds. Draft B concludes that the question of Mr. Hassan's eligibility to receive matching funds is at this point hypothetical and therefore not appropriate for an advisory opinion. We have received 13 comments and 1 ex parte communication on the drafts. I'm happy to answer any questions.
Thank you, Counsel. Is there a discussion from Commissioners or questions for Counsel? Commissioner Walther?
Yeah, I have concerns over approving the opinion as it stands. And I recognize the situation that is awkward in the sense that what we find ourselves in is generally giving a green light to someone to raise money when there's at present clearly no right to hold that office. And so I think we're struggling with why we're doing that, and the finding that the language says if you seek the office, I think most of us assumed that was you're seeking an office you could hold. We're now interpreting it to say it's okay if you're seeking an office that you can't legally hold, and therefore we'll call you a candidate even though you could never legally hold the office as we understand the law right now. So I'm reluctant to go down that road, and I wonder what we would do if we were, and I've gone back and forth on this, if we were presented with a statement of candidacy from somebody who clearly couldn't ever hold office, would we just say fine and have them report? I think it's a tough situation to always think we're going to give a green light to that situation. We have a case right now where this gentleman is before the Second Circuit on an issue that would decide this to the extent it needs it, and the court at present has found that he doesn't have standing at this point to go any further, and I'm assuming that court will still, it'll run its course at some point. And then at that point we might have some guidance. I question whether we should go ahead and answer the question today when there's a pending court proceeding that would resolve an issue that we're confronted with now. So I'm reluctant to proceed to answer the question without giving cognizance of the fact that court case is before us. And I have another issue that bothers me here, and I would agree, I agree with the decisions that this court, this draft C presents. except I wonder if it's wise for us to go down that road at this time. I see our opinion that, yes, it's not a violation of 441H(b), but on the other hand, if we say that, we don't really point out that that particular statute doesn't really relate to the situation here, and it gives the potential for a green light for somebody to waive this opinion and say what I'm doing is legal. Hey, read this, it's from the FEC, when in fact to accept money under false pretenses is illegal in many jurisdictions. And if someone is raising money to run for an office that person cannot legally hold, and in my opinion has a very, very speculative chance of ever being able to hold unless the Supreme Court changes its interpretation of the Constitution, we don't, in this opinion, point out that the implications of that are not, one cannot use this as a defense against these wrongful use of various methods of solicitation. Unless this person is to say, hey, I can never hold office, will you just give me the money and the hope that I can change the Supreme Court opinion? Maybe so, but I don't see that as being likely here, and I think our opinion should take some very careful steps to point out that we can't, no one should construe our opinion to suggest that it's okay to take money under false pretenses or under pretenses that might even remotely suggest that this person could ever hold the office for which he's seeking money. So this is a tough, I've thought about voting for the opinion and adding these thoughts, but I think I'll just vote against it and suggest that it ought to be in the opinion.
Commissioner McGann.
Thank you. I share many of the same concerns that Commissioner Walther has raised, but I think on one question I come down a little bit differently. Going in reverse order, the question of whether this fellow can get matching funds. The answer to that, I think, is no. By having a commission, it denotes that there is some discretion and there is some ability to determine who actually qualifies and who doesn't. And if you read the case law on this, LaRouche was really the seminal plaintiff in these sorts of cases. At the end of the day, we do administer the program, and it's the sort of thing you take a look at it. And I think the comments really capture the obvious answer to this. Every comment, and there's been more than usual, and they're not from the usual suspects. They're not from the lawyers in town or usual political committees. They're from what seem to be just rank and file citizens saying, essentially, you got to be kidding me that someone who's not born in the U.S. can get taxpayer money to run for president when he can't hold the office. That really captures it. The other issue, which is the one where is he a candidate under FECA? That's a little bit trickier because FECA does not address whether or not you can actually hold the office that you seek. FECA is merely essentially a system that requires you to report money that you raise and imposes limits on money that you raise for federal office. Whether you can hold the federal office, that's another issue entirely. People, I think, need to remember, particularly the commenters, that the Federal Election Commission is to a certain extent misnamed. We don't administer federal elections. We're not a commission that decides who can be president. We probably have all had this around election time every other year. Family members will say, man, you must really be busy. Well, we're really not around election time, right? The reports have been filed and that kind of thing. And then people think, you may have gotten this, Madam Chair, Minnesota. Oh, there's this recount. You must be real busy with this recount. No, we have nothing to do with that other than perhaps the financing of recounts, which that's even open to debate depending who you are. The commission, I think, has come up with a workable
We have to answer solution. The questions about recounts, whether we agree.
Right, but we just don't do that here. Nor do we decide whether someone's qualified for office, and that's President and House and Senate. we don't decide if someone's running for the House whether or not they moved into the jurisdiction in time before they were sworn in to be a House member. We don't decide whether someone is old enough. And with president, I don't think anyone has empowered the FEC to decide whether or not someone's qualified to be president. One could imagine the six of us being the institutional us, not us personally, but just over the years, trying to decide whether or not someone was really born here for purposes of being president. Is the Panama Canal Zone part of the United States? I don't know. I'd have to look it up, but I'm not really the one empowered to decide that. So to address Commissioner Walther's concerns, very, very, very astute observations. I have the same concern in that we're going to issue an AO that says, yeah, under FECA, you're a candidate. If you file a report, we're going to accept the report, I suppose. It's going to go on the website, and if you take excessive contributions, you're going to get a request for additional information like any other candidate, and, you may get real lucky and be audited. You may really appreciate being part of the Federal Election Campaign Act's jurisdiction. But none of this has anything to do with whether you're qualified to be president. This person, he admits quite candidly he was not born in the U.S., therefore under the Constitution is not qualified to be president. But the concern Commissioner Walther raises is a very critical concern, and I hope people who realize what we're doing here today hear this. This does not mean he can go and say, look, the FEC has said I'm a candidate, give me money, I'm official. That's not what we do here. We don't certify you as a candidate. That's what the states do. You go, and I have in front of me the New Hampshire, how you get on the ballot form, declaration of candidacy, I blank, that's for your name, swear under penalties of perjury that I am qualified to be a candidate for President of the United States pursuant to Article 2, Section 1, Clause 4 of the United States Constitution, which states, quote, no person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president, neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States, unquote, and a domicile and all that. And so I don't see him getting on the ballot in New Hampshire. Iowa, another state people talk about in presidential elections, same kind of thing. I swear or affirm that the information provided on this form is correct. I will be qualified to hold this office, and if I am elected, I will qualify by taking the oath of office. That has to be, again, under oath. It's an affidavit. Nevada, I pulled Nevada from my friend from Nevada. Same thing. You have to say that, quote, that I will qualify for the office if elected there, too. So, to be clear, the FEC doesn't trump all this. You can't get your FEC card and go and say, I'm on the ballot now in your state because the FEC says I can be president. No, we're not saying that. What we're saying is if you're trying to run, you're going to have to file a report and be subject to all the other bells and whistles that any other candidate has to be subject to. I could imagine a kind of a humorous test case. You could say, well, gee, I can never be president, so I shouldn't be subject to the contribution limits. I cannot possibly be corrupted because I'll never actually be a public official. I'll never be president. This is kind of where the silliness can take you if you have more time on your hands and you know what to do with. But I want to be clear, just simply because we're saying the guy's a candidate for purposes of this agency does not make him a candidate for purposes of state ballot law, nor does it, I think, make him immune from any state laws regarding, for lack of a better word, fraud, the sort of things Commissioner Walther raised. You go to, I'm a candidate, I can be president, the FEC says so. It would not surprise me if a state attorney general said, not so fast, not in my state. Lots of laws, federal candidates run into this on all fronts, state laws on phone calls and fundraising solicitations and the whole cadre of things that come under the consumer protection umbrella and business torts and whatnot. You can't just go out and claim you're something you're not. I would think long and hard if I were someone in this person's shoes about taking what is a essentially close to a ministerial act. Meaning, yeah, if you raise more or spend more than $5,000 to run for office, you have to file reports with the FEC and turn that into something it's not. Because that's really what the word candidate means in FEC vernacular. It means you've raised some money or spent some money over a limit, and you have to file reports. So with that, I hear my colleague, Commissioner Walther, agree wholeheartedly. But the flip side, I think that once he does trigger the statute, I don't think we have the discretion to say, well, yeah, you're not a candidate, because I don't think our statute empowers us to go beyond what we're doing. So I can support, I think it's draft C, the latest draft. But I wanted to state that just so the public understands that the commission, I think we've all heard and all share the concern raised by the commenters. We're not handing out taxpayer money to a foreign national or any of that kind of stuff, and I think it's important to say that we are an agency of limited jurisdiction, and we only do what it is that we do, and we don't make someone a candidate essentially for real, meaning put them on the ballot and let them hold office and that kind of thing. Nor do I think anyone would really want a federal agency to decide that. It's just not the system that we have. The states still play and historically have always played a critical role in electing those who serve in the federal government. So, thank you.
Commissioner Weintraub?
Thank you, Madam Chair. Words you don't hear very often. I agree with absolutely everything that Commissioner McGann said. This is, I think we all share the sentiments of the commenters and Commissioner Walther and you know, sort of the common sense reaction that a lot of people have to this request. But for us, this is really all about what we're empowered to decide and what we're not empowered to decide. And I think also if we came to a different conclusion on question 1, that would permit somebody to go out and claim to be raising funds for candidacy, and then he wouldn't have to do any reporting. It would be entirely below the radar screen. It would all be completely not transparent, and that doesn't seem like a very good result either. So there's sort of bad results all around, no matter how you come out on this one. But I think in terms of what we can and cannot are empowered to decide and what we're not empowered to decide, I think draft C probably comes to the best conclusions.
I will also be supporting draft C, although somewhat, I guess, reluctantly. I share many of Commissioner Walther's concerns, particularly the one about someone being able to go out and say, the FEC has now said I'm a candidate. And I think what the draft actually says is the Act does not prevent him from holding himself out as a candidate, because the statutory definition does not turn on a person's eligibility to be seated for the office he or she seeks, as Commissioner McGann has fully explored. And I think there's a reason for that. I think the drafters of the Act didn't anticipate that anyone who was ineligible to be seated for an office would bother to run for office. So I think it's probably not an error in drafting as opposed to a logical consequence. Nobody would have thought that someone who is ineligible to be seated would go through the bother. And as Commissioner McGann points out, it's unlikely that, given ballot requirements, he could even get on the ballot. So I am also concerned that this opinion may give this individual the ability to seek money from people without them knowing that he's ineligible to seek office. And I actually like Commissioner Walther's suggestion that we tell him he has to tell people he's ineligible for the office. I'm just not sure we have the power to do that. So I think that draft C reflects sort of the limits of our jurisdiction. The Act says has a definition of a candidate. It does not prevent him from becoming a candidate, despite the fact that he would be ineligible for the office. So I'll support draft C, although I share the concerns of Commissioner Walther, and for many of the reasons that Commissioner McGann stated, I think this is the appropriate decision for this commission. And to the extent that there may be civil fraud concerns, there are other jurisdictions who would have authority over those issues. Commissioner Walther.
Got just a little more on this. At this point, and I agree with a lot of what everybody said, because I think the way you come down on the issues is not at all unreasonable. I think for me, I think the opinion should be, if we're going to go that direction, should definitely expand and elaborate on these issues more than it has. In this particular case, if we had a court opinion that says, listen, you cannot run for office I don't know whether we should automatically say, fine, file your statement of candidacy and report with us. We have a case that this is unique. There's a case pending right now on the issue, and it seems to me it's premature to go down the road of saying fine when the court so far hasn't said that. But nevertheless, I know where the votes are, and I'm not saying it's unreasonable. I mean, I've had a tough time with this one myself. But I do think, for example, in our opinion, the statute that we were asked to say it's okay doesn't relate to what's happening here. So by saying it's okay, it does, I think, give an impression that somehow, we don't see a problem. And I'm worried about the way this can be read. And I mean, clearly, as Commissioner McGann pointed out, the comments we got from people here were from people, we never hear from, just people that happen to be reading this stuff and say, hey, can't you guys read the Constitution? What the heck are you spending our time doing this for? Can't you know we can't ever run it? Can you ever really seriously take public money to run for an office you can't legally hold? And so I think we need to be cognizant of how this can be misconstrued, and that the opinion should probably elaborate more on that. Thanks.
Anyone else? Anything further? I think, just to be clear, the case I think you're referring to just does not involve the FEC. So it's not as if there's a pending matter that the FEC is involved in that we're deciding an advisory opinion on. As I understand it, there's a petition for rehearing pending with the Second Circuit, and obviously, should the court make some determination, the Commission would abide by it, but as I understand it, it's not the same issue that's before us in this advisory opinion. And so, obviously, under the statute, we have an obligation to provide an answer to a requester of an advisory opinion. And as I think we've all expressed, there's some reluctance with this answer, but it is the answer that seems to be required by the statute. Commissioner Weintraub.
Thank you, Madam Chair. I just want to emphasize that point because nobody is saying that it's fine, and nobody's saying that it's okay for this guy to be going out and raising funds. What we're saying is we think under the Act there are limits to what we have jurisdiction over, and we just don't have the jurisdiction to decide anything more than whether he's raised or spent $5,000 for the purpose of influencing an election.
Commissioner McGann.
Couple follow-ups. Thank you, Madam Chair. First, I want to echo that the case we're talking about is not against the FEC. I don't think it's not. So it's not as if we're deciding something in an AO that's already in another branch of the government. Two, speaking about that other branch, I mean there is case law that talks about constitutional qualifications for federal office. I don't know of a case talking about presidential, maybe about being born here. Maybe there is. I just offhand have never had to litigate the issue. But there are other qualifiers, and my concern by sidestepping the issue, which the issue is really whether if the guy decides to raise money, does he have to file a report with the FEC, right? And the answer, yes. If you raise money, you've just signed up for all this that's in all these books we have up here. When you look at the case law, it really does bring home that we do have to answer the question, because although what we have here is a unique qualifier, right? You have to be born in the United States to hold office of president. Case law has generally said that whether or not you're qualified is different than ballot access. Whether or not you're qualified for constitutional purposes is really at the time you take the oath of office. And even these ballot access forms that I read have been modified over the years to get closer to that. It used to be in certain states you had to certify you were a certain age and you lived in the jurisdiction and all that to get on the ballot to run for the House. Case law says that's not the case. You don't have to live in the state to run for the House. It's just when you win, before you get sworn in, you have to move in and be a resident of the state. You have to be old enough at that point, not when you sign up to run on the ballot. And if we don't go down the road of saying, gee, if you raise or spend a certain amount of money, you're a candidate, because we're not sure if you're qualified, that puts us in a situation that, again, although we're called the Federal Election Commission, that's just not our deal, because then we are deciding issues that really courts have decided and really are ultimately probably for the judicial branch to decide vis-a-vis what the Constitution means. If you have someone who claims, there was a case in Texas, and I was, in full candor, I was involved in it, where candidate won a primary, moved out of the state, said, there's no way I'm moving back to the state anytime soon, so even if I win, I'm not going to be eligible to be in the House, therefore I'm going to take my name off the ballot. And the party wanted to fill the ballot line. The other party sued and said, you can't, because actually your nominee is not qualified or disqualified at this point. You're not going to know till they take the oath of office. Judge Sparks down in Texas wrote a very persuasive opinion that said, yeah, the plaintiff was absolutely right. Whether or not someone's a resident of the state, well, we don't care about that until it's time to be sworn in. Judge Sparks just recently made the news because he's the judge that just enjoined a Texas law on abortion that just got out there, and I just saw his name in the paper. So I remember Judge Sparks. It was a Bush appointee, although apparently a registered Democrat. Interesting guy, he left a local bar. He calls the balls and strikes, and I remember this opinion. He saw right through this move out of the state thing and said, no, Constitution only kicks in when you're sworn in. And I thought of that case, and I looked at some other cases, and that tends to be how the federal courts come down, is the qualification is something that is different from running. It does put us in a weird spot. Someone's running for an office that I think everyone knows he's not going to be able to hold because the president does have that unique qualifier. But if we get into case law, I think to me the case law requires us to answer the question and say, yeah, you have to file a report to the extent, without getting ahead of everyone else, to Commissioner Walther, if there's some language we could add, a footnote or perhaps acknowledging a pending case or that kind of thing to give you some more comfort, I'm happy to do that. But my sense is that that's not a necessary thing to resolve the AO. But I don't like the answer either. But I'm going to vote for it because I think I have to. And if there's a way we can all join hands and jump over the precipice together, I'm more than happy to do that. And with that, I yield back. And maybe there's no way to do that, but if there is, I think there's some appetite to do something along those lines, even just to drop, the case or is a different issue, or we're not answering the questions beyond our jurisdiction, or something to that point. Whatever may help you get there. I think, at least for me, more than happy to put that in.
Commissioner Walther.
Yeah, I can warm up to that. I think, let me point out, though, that this particular case, the Court of Appeals has said the district court determined that the complaint failed to state a plausible claim to relief and therefore dismissed the complaint. And that was under Federal Rule 12b, failure to state a claim upon which relief can be granted. It has directly the issue before any court that would have to the federal court to decide whether or not this person could ever sit as president. And then the Second Circuit appealed, concurred, in addition to having lack of standing, affirmed the decision. So we do have a district court decision. I'd warm up to that if you wanted to, just to give reference to the fact that there's a pending case, dealing with the issue. But I would also suggest that we add a sentence or two toward the end that clarifies, if the case is any question, that our opinion does not inoculate people from claims for potential claims of accepting money under circumstances that are misleading.
If I might, just to make sure we're all clear, the case that Commissioner Walther is talking about, it was a claim for declaratory relief that the 14th Amendment of the Constitution trumps the natural-born provision of the Constitution. So obviously, I think, as Commissioner Walther or Commissioner McGann has said, that is not an issue that this body could decide in any way, shape, or form. As Commissioner Walther indicated, the Second Circuit panel affirmed, the district court dismissed, the Second Circuit affirmed on grounds of standing. There's now a petition for rehearing. I don't have any opposition to noting that this case is out there. It's the same, the requester is the same as the plaintiff, but I don't think it has any bearing on what we decide under the FECA. These are constitutional claims. Whether the 14th Amendment trumps that provision in the Constitution is something that I guess if I envision that if it were to be decided by a court, it might be decided by the Supreme Court, and ultimately not by lower courts. So, as I said, I don't have any issue with identifying the fact that this case is out there, but I don't think that it has any bearing on the FECA. Commissioner Weintraub.
Thank you, Madam Chair. I also would be happy to consider any language that my colleague would care to suggest. But I do want to point out, and this is mentioned in a footnote, that the Act does not contain separate definitions for candidates for different federal offices. There's an overall definition of what a candidate is, and obviously there are different qualifications, different eligibility standards under the Constitution for House and Senate members as opposed to the President. A naturalized citizen can hold other offices in the United States. I'm thinking of governors at the moment. Arnold Schwarzenegger springs to mind, but and obviously he's not in the federal system. But you know there are naturalized citizens who can be in the Senate and in the House. The fact that the Act doesn't distinguish in its definition of candidate, I think, is another indication that Congress did not intend us to be the arbiters of who meets the constitutional eligibility qualifications for president. But as I said, I'm always happy to consider language from my colleagues that would address an issue of concern that they have.
If I could ask Council a question on timing in this AO, when is our 60-day deadline?
I don't remember offhand. Second.
Does September 5th sound accurate? Thank you. All right. I'll ask my colleagues if there's a preference to try to resolve. We have only a few days to try to resolve this. I'm happy to consider additional language. Obviously, since there was a new draft this morning, we have been considering additional language right up until fairly early before the meeting. So, Commissioner McGinn.
I can support what's before us today. I threw it out as because I sensed perhaps there was an opportunity to have a unanimous opinion. I can go either way because of the timing, but the offer remains open. That's really, if Commissioner Walther feels he can at the end of the day support something, then maybe it's worth taking a little time. If he thinks that the issue is in the courts or is something that is another branch of the government's deal, just to throw out there, I mean, I'm sure the U.S. House probably thinks they're going to have a say in whether somebody can be president. I mean, if you actually read the whole Constitution there, it's kind of a complicated thing how you get to be president. And every branch seems to think they have a say. But I can go either way. So it's up to you, Madam Chair, because of the timing. Whichever way you want to go, I'm fine.
Commissioner Walther?
Well, I'm willing to give a shot at some language, and maybe by the end of the day, see if that works. If it doesn't, then you've got the votes to go ahead.
Okay. Okay, so we will not take a vote on this matter today. We have a few days to resolve this matter before a 60-day window runs. So, with that, thank you, Council, for your work on this matter.
The only people who don't want to disclose the truth are people with something to hide.